So I'm going to go ahead and get started and do a bit of intro so folks can catch up who are ultimately coming in a minute or two late. So welcome everybody to our webinar on operational level grievance mechanisms. As you know, I'm Jonathan Drimmer. I'm going to be moderating the panel. I'm a strategic advisor to the Secretariat of the VPs, also a senior advisor to BSR, where Ouida is, and a partner at the law firm of Paul Hastings. And we'll be talking today about operational level grievance mechanisms and talking about them both from the process standpoint as well as the substance standpoint. So we'll be looking at the procedures in establishing effective and efficient and inclusive operational level grievance mechanisms, OGMs, but also how remedy is ultimately considered and determined in connection with grievances that are raised into OGMs. So we have two of the world's leading experts with us today, and so we are quite lucky in that respect. We've got Lloyd Lipsett, who's a human rights lawyer from Canada, who has a tremendous amount of experience in the business and human rights space, human rights due diligence, human rights impact assessments, has worked with a lot with mining companies, with the extractive sector more generally, done a lot in connection with the voluntary principles in terms of risk assessments and training, engagement with both public and private security forces, and has tremendous and in-depth expertise in helping establish, evaluate, monitor, and otherwise advise on OGMs. And he's in the period of moving actually from Canada to Tanzania, where he'll have more of a regional focus in Africa. So welcome, Lloyd, good friend of the VPs. Another good friend of the VPs, and both are friends of mine, I should proudly say, is Ouida Chichester. And Ouida leads BSR's energy and extractives practice. She has a background doing international development work. She works with global companies across industries, but again, extractives is really where she does lead the BSR related work streams, works with communities, works on issues related to inclusive economy, diversity, women's empowerment. She was with the UN development program in Belize before joining BSR, focusing on issues like water governance and gender equality and disability rights. She has a background in civil society as well, and has really worked around the world on a variety of different issues related to business and human rights, and in particular on issues related to remedy and remediation. So we're incredibly lucky to have both of them with us today, and we're gonna keep this conversation on a fairly informal basis. Lloyd will kick us off with some reflections on issues related to establishing OGMs. We'll chat about it a bit. Ouida will come in, talk about remedy. We'll chat about it a bit. Please do not hesitate to raise your hand or ask a question in the chat. I'm very happy to take questions along the way. Again, want to keep this relatively informal. But with that, Lloyd, why don't you go ahead and kick us off?
Well, thank you very much for the very kind introduction, Jonathan, and very nice to be a participant in this webinar. And with all the attendees, I scrolled through the list and recognized some names. So hi virtually to those that I know, and be a pleasure to have this opportunity to speak to those that I don't. So I'm going to talk a little bit about developing operational grievance mechanisms, and I'm going to talk about some of the more elaborate ones that I've had the opportunity to work on in the last few years, which I think are illustrative of where this space of remedy and grievance mechanisms are moving. And obviously, when you're developing an operational grievance mechanism, the touchstone for that is the UN guiding principles, effectiveness criteria. And I think a couple of things that these more elaborate grievance mechanisms bring to the fore are the importance of having a lot of participation and consultation in order to establish the legitimacy of a fairly elaborate grievance mechanism that can deal with human rights related issues and complaints, as well as having increasingly components of a grievance mechanism that are more and more independent from companies, again, as part of the legitimacy to address more serious types of issues. Now, the kind of way that I go into the development of these more elaborate grievance mechanisms with a bit of a prototype in mind that, simply put, has a number of different tiers to it. And what we like to call the tier 1 mechanism is your normal company-led grievance mechanism that can deal with operational issues where it is both legitimate and effective, and also I think appropriate that a company takes responsibility for managing and addressing issues that come up, whether it be related to workers or communities, and that is seen and felt as legitimate. Then there's also what we refer to as a more of a tier 2 mechanism, which is has a much greater degree of independence and is designed specifically to deal with more serious allegations or complaints about human rights related matters. And so if we use kind of, we're in the VP's context here, if we use a couple of security examples to illustrate this, you know, if a guard has a complaint about his or her uniform or living quarters or the meals in the cafeteria, this would be something that would be appropriately addressed by a tier 1 mechanism and hopefully done in an effective and respectful way. Now, the tier 2 mechanism might deal with a grievance related to a beating by a security guard or public security forces associated with a company, or an instance of gender-based violence or rape or something very serious. And there, the imperative is to have a more independent type of mechanism, and I'll describe some of the key features. I think as we think about these mechanisms, either the tier 1 or tier 2, we want to also think about pathways for escalation or appeals, so that if there is disagreement at the end of the investigation and determination process, there's a way to elevate the issue and have a second look at it. And increasingly, we want to have some sort of formal monitoring and evaluation function. And with some of these more elaborate grievance mechanisms, there's a requirement to have an independent monitoring function that can provide recommendations around continuous improvement, as well as a certain degree of transparency, once again, to help reinforce the legitimacy of these mechanisms. Now, just to quickly go through some of the key components that we're thinking about when we're designing an elaborate grievance mechanism. One, obviously, will be determining the scope of the mechanism and what are the criteria for triage between the operational type grievances and the ones that should be elevated to the more independent mechanism. And also, I think, thinking about certain types of issues that might be outside the scope altogether and that need to be referred to other non-judicial or judicial mechanisms. And sometimes with serious allegations of human rights abuse, you're going to be by definition dealing with criminal matters. So how do you unpack that in terms of what a company can legitimately do in terms of providing remedy to the complainant, to the victim, and what are things that might need to be handed over to the authorities for other types of investigation and sanction, and under what conditions you do so. These mechanisms, if they are going to be successful and to be consistent and predictable, they need a bit of architecture to them. So you need to think about administration and what we sometimes like to call some form of secretariat, or at least a person, a grievance officer, someone who is responsible for that, and building some systems around that that will help with the management and the tracking of the grievances over time, so it's not done on the back of an envelope. And as many of you will know, there is now increasingly sophisticated software and management systems that can assist with that. And as we go through the step-by-step, then you think about investigations, and this is particularly important in the case of more serious human rights allegations, to have trained investigators who can gather the facts, who can do so in both a way that is rights respecting and doesn't submit the complainant to sort of additional trauma and going through that process, but also to do so in a way that compiles and manages evidence and documentation in an appropriate way with the appropriate safeguards on confidentiality and so on. After the investigation, you need to think about an individual or a group, a panel that will do the determination on the grievance mechanism or of the grievances. And then, as I mentioned before, potentially some form of appeals person or panel. One of the things that's very important to have a rights respecting grievance mechanism that deals with more serious issues are a series of supports or safeguards that can accompany a complainant through the process. And this can range from psychosocial support to legal representation and to some logistical supports as well. So what are the sorts of things that will help someone go through a process without additional trauma, and which will also give a certain degree of equitability in terms of their ability to process information and to participate in the process on an equal footing. Obviously, these are all about remedy, so it's important to think about a remedy framework, which can involve a whole range of different types of either processes or outcomes. And I think what we see on the ground is there's a huge preoccupation, particularly in developing countries, around cash compensation, and that has its issues. It has problems in terms of people's expectations, and also the risks around secondary human rights abuses when large sums of cash are awarded to people, and that can cause issues within communities, within families, and so on. So what are safeguards around remedy when cash compensation is the main expectation for people? And our experience has been, we try to encourage alternative forms of restoration and non-cash compensation, but it's sometimes difficult to get people to agree that that is the form of remedy that they desire. And finally, we mentioned before the idea of some sort of learning evaluation function. As you know from the guiding principles, these mechanisms are supposed to focus or to have a degree of continuous learning involved with them. So what is the monitoring and evaluation function that is attached to the mechanism? And then just very quickly to round up, and we'll open up for some dialogue, is in terms of the process for setting these up. Typically we go through a process of kind of a scoping mission where there's a lot of consultation with internally within the company and externally within the communities to try and understand what are the types of cases that are likely going to arise in the grievance mechanism, which help to develop the process and also the remedy framework, as well as some of the supports and safeguards that are needed. It's important to understand the broader ecosystem of remedy in the country and what are some of the potential referrals that the mechanism will need to or may wish to avail itself of, and also to understand the level of trust between the company and its stakeholders, because sometimes that'll be very determinative of the degree of independence that is needed for dealing with some types of issues, as well as basically the willingness of people to use the mechanism. When you're developing the more operational company-led part of the grievance mechanism, I think a lot of it is around bringing some formality to things that are being often done quite informally. There are always ways that issues are raised and get addressed, but now to kind of try and put some procedure on that. And that often is around an opportunity for training and learning about the guiding principles, the effectiveness criteria, and trying to develop a bit of a more comprehensive and principled way of pulling together all the different informal ways that companies typically just address things on a day-to-day basis. And then when you're dealing with the tier 2 component, or this more independent type of mechanism, a key will be around who you get involved, the credibility, the stature, the independence of the different people that will be involved. I mentioned, there's a secretariat, there's potentially a panel, an appeals function, an investigative function. So the recruitment of those people and with the appropriate skills, but also the type of credibility that will bestow some legitimacy on the mechanism. And sometimes we've found that the selection process, by involving civil society organizations, community representatives in the selection process, is one of the ways early on of building legitimacy and some credibility around the mechanism, if key stakeholders feel they have a stake in selecting the sort of the figureheads of these mechanisms. So I'm going to stop there just in terms of a quick introduction, and look forward to any questions you have, Jonathan, or from the others.
Terrific. Thank you so much for that, Lloyd. We actually do have a couple of questions in the chat, but I'm going to actually, and obviously, Ouida, you should feel free to jump in as well in answering. I do want to use my prerogative to ask the first one that I continue to find vexing in the context of OGMs myself, and as you know, I've done and am doing a fair amount of work in connection with remedy and grievance mechanisms, and that is dealing with human rights grievances, which often themselves may have potential criminal liability connected to the perpetrator. And on the one hand, when we think about establishing credible OGMs that satisfy the UN guiding principles, we want them to be able to handle human rights related grievances. And at the same time, because they do sometimes have criminal components to them. So the OHCHR guidance is that in the ecosystem of remedy, grievances that give rise to potential criminal liability should be remedied through judicial mechanisms whenever possible. So they give a preference to judicial mechanisms. And so how have you and Ouida as well, both of you, seen effective OGMs really balance that? Grievances that have a criminal component, with providing remedy, with not undermining judicial institutions, with engaging with public authorities over it. Any insights?
I think it's a really important issue and a complex one, and it's very context specific. And I think it comes to a point you made in the introduction, Jonathan, about the, the rule of law and the sort of I guess the credibility and of the broader judicial system. And also, I think, who are the alleged perpetrators? And, we're talking in the VPS HR space, and, this can be very touchy or tricky when you're dealing with public security forces who are the alleged perpetrators of a crime or a human rights violation. And I think the way we've tried to approach it is to separate out two components of remedy. One, which is the victim-focused part around providing remedy, restitution, rehabilitation to the individual who is affected, which can be done by a company a bit outside of the judicial system and often can be done more effectively. Mm-hmm. And it doesn't necessarily require the same process and evidentiary thresholds of a criminal prosecution. And also, in some countries, criminal prosecution may result in a punishment, but may not provide much in the way of actual remedy to the victim, other than, that justice has been done. Now, so that's the one piece that I think is more comfortable to deal with within the OGM space. Now, when you turn it over to the other part, which is the criminal prosecution part of it, there can be a lot of fears that could, potentially have retribution, or experience may be that, it actually it's not going to serve any purpose. Someone's going to pay someone along the line, and this case is going to go nowhere. So I think one of the key principles there is around the consent of the victim to pursue that, and also to use the people within the independent mechanism. So the head of the mechanism, or someone to kind of be the point of referral, someone who is perhaps less vulnerable, perhaps more educated, who can lead that referral process and survey it, and act as a bit of a deterrent for retribution, so that you're not just handing over a sensitive issue to the judicial system without some supervision.
Terrific point. Hey, Ouida, do you want to comment in on that, and then figure out a smooth way to segue into your discussion of remedy?
Yeah, sure. So, I think the point that you bring up, Jonathan, is a really difficult one. And I have to say, in my work, I'm really glad to hear Lloyd be able to speak about some ways of it working well, because I feel like in my work, what I mostly find is that it's not working terribly well. Mm-hmm. And, often, no offense to any of the lawyers present, but often when it is a criminal matter and company lawyers get involved in the issue, what I find is it often gets immediately sort of taken out of the grievance mechanism process, and any of sort of the good procedures that were outlined in terms of how to handle a complaint, and having, it be, centered on the victim and them being involved. As soon as it becomes a liability issue for a company, that it often gets immediately taken out of that. And I think one of the biggest challenges that companies face in my mind to really providing remedy in these situations is how to keep the legal team involved and educated around what needs to happen from a human rights perspective, when some of these concerns are raised, and that it doesn't immediately just be treated as a company liability issue with sort of all the power of the company thrown behind the issue to protect the company. So that's often more what I see, and am really really like Lloyd's comments about kind of how that can actually be be done better.
Terrific. So you want to talk to a little bit about remedy and good practice around remedy and what you're seeing more generally with?
Yeah, sure. So I'm going to kind of take a little bit of a step back, and and share a little bit kind of more sort of big picture in some of this that I think might be helpful. Can you see my screen? You see the
Yep,
slides?
you're good. Yep,
Excellent,
yep.
great. So just, I know all of you on this call are sort of experts in, in your own right, but just so we're very much on the same page, I'm going to start with some of the basics. We all know that sort of the third pillar of the guiding principles is around access to remedy. And it really outlines that victims of corporate related abuse must have access to mechanisms for effective remedy. I really think this is the least developed, or at least well understood or practiced pillar of the guiding principles, and one that I really think deserves a lot more attention and figuring out how to do this well. And I think among sort of practitioners and within companies, what I often see is that remedy is often understood as the need for effective grievance mechanisms or community feedback mechanisms, but not actually really thinking about, okay, access to these mechanisms is often really just the beginning or this procedural aspect of remedy. And it's not actually effective remedy itself. So the UN guiding principles, kind of outline that businesses should, establish or participate in these effective grievance mechanisms for potentially impacted stakeholders. And, the UN guiding principles also, provide sort of effectiveness criteria for these grievance mechanisms, particularly non-judicial grievance mechanisms. However, they offer very little guidance itself on remedy and the substantive elements of remedy. So if you're just looking at the UN guiding principles, you kind of fall short when it comes to remedy. And really, for actually thinking about remedy, you really have to look to other human rights instruments to really understand what effective remedy is. So as I kind of mentioned and we've sort of alluded to before, there are kind of two elements of remedy, and it has sort of this procedural as well as substantive aspects. And this procedural aspect kind of refers to the steps that must be taken before remedy can be obtained. So the name process. And the elements of this really, refer to, grievance mechanisms, or could be kind of due diligence processes, could be stakeholder engagement. And it's really the sort of conduit to being able to then finally, provide remedy. But it shouldn't really be confused with kind of remedy itself. The substantive aspects is really, this is what considers the different elements of remedy that Lloyd started speaking about, and I'll dig into a little bit more. And this really looks at whether remedy has been kind of efficient or effective. And a key point here is that providing access to mechanisms is really not enough. There really has to be the outcome, like what actually comes out of this process. And at the end, there needs to be effective remedy, and the rights holder needs to be restored to the status that they held before whatever harm it was done to them. Kind of situating in this and thinking about the various different kind of pathways to to remedy. A company operational level grievance mechanism is really just kind of one amongst many different kind of ways to get to remedy. It just happens to be the one that companies often sort of pay the most attention to, and really, I think in part it's because kind of given the level of responsibility that companies have in those mechanisms, as well as the amount of sort of control that a company has there. So that's sort of why we tend to focus so much on that. But really, there's a whole kind of ecosystem, as Lloyd mentioned, around getting to remedy. And so kind of thinking about, remedy and grievance mechanisms, and Lloyd really spoke about this as well, is that rights holders really need to be at the center of any kind of remedy process. And effective remedy really requires seeking the perspective of stakeholders who've been harmed. You can't provide remedy without having that engagement. It's not remedy. So in some examples of this, kind of rights holders should have no fear of victimization when seeking remedy. Really, this is an integral component of access to remedy, because there should be kind of no additional harm caused to the person in the process of kind of redressing that initial harm that was done. And we see that, there are cases of rights holders, including kind of social activists or human rights defenders, that kind of in their search for remedy have faced, intimidation, arrest, criminal defamation charges, and even sort of forced disappearance and murder. Remedies should also be responsive to the diverse experience and expectations of rights holders. So this is going to depend, remedy is going to look different in different situations. So their experiences, their perspectives, their interests, their opinions, will kind of vary. And so on a case-by-case basis, it's really, important to determine the remedy that's based kind of according to their needs. And really, remedy can take a range of substantive forms to counteract or make good on any human rights harm that occurred. And I'll go into kind of what these are in just a minute. And kind of much like the kind of effectiveness criteria for OGMs, there is sort of a criteria in looking at effectiveness of remedy, and they're very similar, but they are a little different. And that's sort of the former, the effectiveness criteria that's set out in the UN guiding principles, reply to the procedural aspects of remedy, whereas these listed here refer more to the substantive aspects of remedy. And for these, it should be accessible, it should be affordable, it needs to be adequate and timely. I think the timely piece is one that's really, really important, because in my work, some of the things that I come across often is the legacy issues that are in communities that are just sort of festering there, that don't make their way to the operational level grievance mechanisms, except for in some extraordinary cases. And kind of everybody knows they're there, but they're not in a system, and so they're not addressed. So that timely piece, I think, is really critical to to think about as well. So actually getting into what are sort of the elements of remedy, and the UN working group kind of also refers to this as sort of the bouquet of remedies, but really it's just kind of the list of what actually constitutes remedy. And this has kind of 5 recognized forms of reparation. And it really includes a broad range of measures that can be used to, repair the harm that was caused to rights holders. And kind of, as I mentioned before, there's no kind of one size fits all remedy. Different remedies may be, more effective in different situations. And that's why it's really critical for those rights holders to be that kind of active participant in determining what remedy looks like. It's equally important to note that, access to remedy is not about pleasing people, but it's really about understanding the harms that occurred and working to restore the rights holder to the status they held before that harm occurred. So I'm now going to kind of go quickly through each of these, but sort of restitution. So restitution, as its name implies, is really intended to restore, to the extent possible, whatever has been lost. That could be, someone's position in the community. It could be their property, their liberty, or or something else, and restore the rights holder to that state, preceding the harm that took place. Compensation, as Lloyd rightly mentioned, is the most kind of commonly sought after and granted for business-related human rights abuses. And if it is used, it should be fair and proportional. And and really a compensation is really only appropriate in those cases where damage can be economically assessed. However, it's often used much more widely and broadly than that. When it comes to the next one is rehabilitation, and so this covers, medical or psychological care, social or legal services that are needed to actually restore the rights holder. Satisfaction, it sort of has a more legal use of the term satisfaction, but really it's non-financial forms of reparation for moral damage or damage to the dignity or reputation of the rights holder, and it can really take multiple forms. It can include such measures as a cessation of the violations, an acknowledgement of the harm done, public disclosures of the truth, public apologies from those responsible, as well as kind of sanctions against those responsible for the harm. I think this is one that we should probably be using a bit more. Finally, looking at, this is similar to some other pieces, but the guarantees of non-repetition is really important, because remedy, and a key piece of remedy, is that it has a key role in preventing future abuses. So remedies should be able to discourage not only sort of a given actor, but also others sort of within that kind of wider sphere of sort of committing the same or similar abuses in the future. And so guarantees of non-repetition can include a number of measures to prevent future abuses. So like changes in policies, procedures, even laws, or oversight. And I think as an industry, the kind of extractives industry, I think we're not very good at the sort of guarantees of non-repetition. I don't think we learn very well from each other's mistakes. So I'd really like to see us sort of work a little better on this kind of guarantees of non-repetition and kind of working on that piece. I'll go through just sort of quickly some of the things that we're seeing at BSR when it comes to remedy. We're increasingly seeing that cases are being resolved through lawsuits, and with somewhat mixed results on actually providing remedy. Some companies are kind of learning from this and working with their legal departments to kind of proactively address issues. But we're really mostly seeing that in companies that have really learned from a past challenge in a hard way, especially sort of those that have garnered like a lot of media attention. We also see companies establishing these sort of more independent grievance mechanisms that Lloyd was speaking about, kind of with the understanding that kind of their standard, level 1 operational level grievance mechanisms are not always the best, and quite frankly, generally are not the best suited to deal with human rights issues, or in some cases they're actually being required to do this as part of a legal settlement. A third trend that we're seeing is increasing calls by stakeholders for companies to actually address some of these legacy issues that I spoke about. So kind of these issues from the past that haven't been addressed, or also these cumulative impacts that have caused harm over time. And then finally, we're kind of seeing growing demands on companies to address some of these racial injustices. And I have some kind of examples of what this looks like, but I think I'll just kind of stop there. And open it up for some questions.
Terrific, thank you, Ouida. That was really a terrific run through the background and substance and trends of what we're seeing on the remedy side. Really appreciate it. Let me ask you a question. We have a bunch of questions in the chat, so let me ask one that to get us started. And obviously, Lloyd, feel free to come in too. And the question is, it's part process and part remedy. What's the best and most responsible way to provide legal and logistic and psychological support to claimants, people who file grievances, without risking or being accused of risking influencing their actions? How do you balance the logistical, legal, and psychological support with perceptions of influence?
Yeah, it's a really good question. And Lloyd, I'd love for you to jump in. I think you've got a lot of experience kind of on the ground of what that looks like. But I think there has to be degrees of separation. It can't just be sort of the company providing that. I mean, that would be kind of undue influence. So there needs to be degrees of separation and independence. So if the company does want to do that, to set up an independently run group that can actually do that. But yes, the funds come from the company, but the company doesn't have oversight. It doesn't have say in kind of how who those funds are given to and how the funds are distributed. So just having that sort of a separate entity that can actually do that. Otherwise, I can't imagine a way that a company could do it that wouldn't exert sort of undue influence. But Lloyd, jump in. Maybe I'm off base here.
No, I think you're right on point. And I think there's, as you say, it's a question of a degree of separation in some of the independent mechanisms that we've worked on. That secretariat for the independent mechanism does a lot of that in terms of the logistical support, the administration of remedy. They would be the conduit for the award. They would be between the company and the complainant in terms of getting with its financial compensation, getting the money, dispersing the money, ensuring that there's financial literacy training or whatever other safeguards you might put around the disbursements of compensation. You touched upon the importance of rehabilitation and so on. So having an NGO with psychosocial support expertise, kind of having them on standby with a mandate that in certain circumstances, we will call upon you to provide those services. And that's all set up as part of the establishment of those procedure, where you get specialized organizations, civil society, sometimes also, governmental or paragovernmental organizations around. We've seen ones that do mediation and other sorts of services. So you can get some service providers that are around it, but at the core of it, it would be this kind of the secretariat of the independent mechanism that would coordinate all of that and ensure that it is done with that sort of arm's length and have the appropriate safeguards and procedures in place.
Let me give you another one, and this is another good question. And I think companies have increasingly and appropriately been thinking about how to create sustainable infrastructures after they depart. And obviously for the extractive sector, there are limited lifespans for a lot of our assets. And we think about it a lot in terms of employment. We think about it in terms of schools and hospitals and other core community components. How's it going to operate when we go? What about OGMs? Have we had any good thinking, any good examples, or how should companies think about ensuring the continuity of an OGM after a company leaves or concludes its operations? And maybe Lloyd, start with you, and then Ouida.
It's a great question, and I don't think there has been sufficient thinking about that. And some of the independent mechanisms that I've worked on have been put in place to deal with some of the legacy issues that Ouida mentioned. And so they're almost set up with a sort of a temporal mandate, and that once they've addressed some of those things, the theory is it might be able to cease its work. Now there's questions then about whether there's some value in continuing and so on, but this sustainability question is maybe not been considered sufficiently. I think obviously the ways that I would approach that would be is in the operation of the grievance mechanism and situating it within that broader ecosystem of remedy. Are there places or institutions that can sort of step in to sort of take over the mandate after it's gone? Is there a way, a bit like you would do with some sort of environmental monitoring after the closure of a mine, to say that this independent mechanism that we've established, we will sort of keep it up and running for a certain period after closure in order to ensure that any cases that might come out of the woodwork have been dealt with, including, you know, there probably can be issues that arise related to closure. So I think it's a really great question, and one that we should think about. But as I say, sometimes the premise going into these more serious or the more independent mechanisms has been to have a very specific mandate to deal with the legacy issue, which is almost the opposite of you know, what the question is driving at.
Yeah, I think it's a great question too, and like you say, Lloyd, and we very interested in your view. I have not seen a lot of progressive thinking or action around this issue. I actually think, you know, again, we are, I think, in a lot of ways turning our attention much more to impacts post-operation, economic impacts, other impacts, including those that have direct and indirect human rights components. And this is one that we probably ought to put on the list that should be the product of further thinking. But we don't know if you have a different take or different experiences.
No, I mean, I completely agree with everything Lloyd said there. I would just add that I think this is going to become more and more of an issue as we sort of work our way through the just transition. And there's more and more, you know, in the oil and gas sector in particular, you know, sites that are decommissioned and changing there. So I think that now is really the time to start thinking about and establishing what good practice looks like here, because I think we're going to need it more than ever going forward. And there's just a few things that I have in mind that I think that as part of that decommissioning and sort of closing down a site, you know, thinking about uncovering if there are legacy issues and addressing those as part of the, you know, the closure process, and making sure that once sort of a company has kind of left the area, that there aren't kind of those lingering legacy issues from, you know, 20 years ago, that we're sort of starting at least from kind of a clean slate as part of the decommissioning process. And then as Lloyd mentioned, sort of ensuring that there is sort of a process where any kind of new grievances that arise through that sort of closure process and for a number of years sort of post closure, that there is sort of a mechanism that, you know, people can go to raise complaints. But I have a real concern that there are going to be a number of legacy issues that are just never resolved, or, you know, who then is responsible for this kind of post closure, and that's going to be a really important piece to be thinking about in that decommissioning side.
Terrific. Let me come back to something that Lloyd brought up before, and Ouida, I know you dealt with. I want to start with you on it, and it actually connects to one of the questions in the chat as well, and that's cash compensation, monetary compensation. Because on the one hand, often in developing countries where we operate, that's really what local community members at least think they want, right? That's where they start their requests. But monetary compensation, cash compensation, comes with it's a fraught process, and it comes with a whole bunch of challenges if you go down that road, in terms of quantum, in terms of benchmarking, in terms of undermining state resources, in terms of retribution. And so my question is, you know, from your end, Ouida, in thinking about remedy and how to address what claimants are asking for, monetary compensation, versus how things are set up, how are you seeing effective grievance mechanisms balance that? And it connects to the question in the sense of best practice of achieving remedy where satisfaction is ultimately sought? How do we know that claimants are satisfied? What about things like public apologies? So it feeds into that larger question of different remedy options.
Yeah, it's a really good question, and I think it's really tough. And I think there's a piece that I think is important in some of this, is that remedy is not about making people happy. And I think that we sometimes lose that piece. And I think the name sort of satisfaction in that one of that is a little misleading, because it isn't really about is everybody happy. Like, that's not really what remedy is about. It is about kind of restoring the individual to that position that they held prior to the harm being done. So I think part of it is sort of rethinking how we're talking about remedy. And yes, it's really important for the rights holder to be at the center of every approach and to be involved in it. But it's not about them, enriching themselves through a process. That's not the intent of remedy. And so I think that's where it just gets super complicated, of trying to understand what kind of, to use the UN working groups, like what kind of bouquet of options is going to really restore that individual. And the compensation piece, like I honestly don't have a great answer for that, of how to figure that out if you're engaging with local stakeholders and who have been harmed, and that's what they want. Then it's sort of explaining, well, that's not going to restore the individual to to the position that they held previously. And so I think it's really about making sure that remedy is not just sort of picking one of the five elements of remedy, but really trying to build out sort of a remedy package that's really comprehensive. And it may have some compensation in there, but it's not just about like getting paid. That it really needs to think about that restoration and restoring the individual. But it's not easy. Like there's no sort of easy way to do it.
Yeah, let me come back to you, Lloyd, with a little bit of a twist on this. Which is, if you don't provide monetary compensation, do you risk loss of credibility of the OGM to local stakeholders, particularly, and I'm feeding this back into a question we received, particularly where you've got weaker judicial systems that people tend not to trust. And so on the one hand, if you don't provide monetary compensation, you may lose credibility for the mechanism, and there may not be anywhere else for people to go if they do want monetary compensation as a result of a harm that they may have suffered.
Yeah, great question. And I think, once monetary compensation is on the table, maybe it's human nature that's what people are going to want or expect. And, if that is the type of remedy that is provided through, the legal system and other things, why not here? I think there is and often where you're establishing these mechanisms, there has been a precedent set where some people may have gotten cash compensation, and once the precedent's set, it's hard to undo. So I think the approaches are around a few pieces. One is a lot of expectation management, and I think there needs to be we put a lot of emphasis on public education campaign and rolling out these mechanisms. You don't just throw the switch or open the door one day. You need to really educate people about not only the process, but what are the type of outcomes, and in that process of explaining the types of outcomes that the mechanism can give, to use the bouquet. I hadn't heard that one. I like the bouquet analogy. Here, the bouquet here, and here are the pros and cons of these different pieces. And I think also when it comes to financial compensation, I think it is important, whether that's done through public education or conversations with the complainant when it gets to that stage of the process, to really talk about the risks related to financial compensation, which in a poor developing context can be quite significant, and to talk about be very serious about the safeguards that you will put in place and to offer alternatives. And I think the other thing is I like the idea of, the bouquet or a package here, that it's not, a menu where you choose one thing. It may be a combination of things, so that I think if someone is entitled to compensation, they should be entitled to an apology. And the piece around non-recurrence, about explaining how, the guiding principles say that remedies should also, or OGMs should feed into your system of ongoing due diligence. So explain how we're learning from this and we are going to make things better. And I think that, I don't know if that's part of satisfaction, but I think, for some people, it takes a lot of courage to raise an issue, especially a serious one, and they might be motivated or feel better if they think, well, because I stood up, this won't happen again to someone else. So I think it has to be a conversation around that package of things. And I think the expectation management up front is really crucial, or else you may create the impression that this is an ATM, and that's not going to be helpful.
Yeah, no, for sure not helpful. Well, tricky issues. We've only got 2 minutes left. I do want to give you each just a final word on this point, 30 seconds or less. So as we head into, what 2022 is going to be the year where we are going to see more and more focus on mandatory human rights due diligence bills and legislation, what we're expecting, within the next few weeks, something out of the EU. They all include grievance mechanisms. They all include grievance as a component of the mandatory due diligence side. And one of the elements that we haven't touched on, and that often isn't touched on, is public reporting. And what does good externally facing reporting look like in connection with grievance mechanisms? Just a couple of quick thoughts in light of the time.
I'll kick off. I mean, I think there's two elements. One, there's the public reporting piece and what you will put in your report. And I think there will be, in your sustainability report, we see more and more detail that is being provided, not just numbers. And I think giving a flavor of what types of issues. And again, it's about giving a flavor of what the process is and what the possible outcomes are. That's important. And also, I think there's more and more honesty in reporting about what the challenges are. But I think what's even more important than what we put in the glossy brochures or reports is how you feed back on the ground, and that there's communications back to the community, back to the workforce about how these things are done, both to convey the message that we're learning from this and we're improving from this, but also to help manage expectations about what are the process and the outcomes using live examples. So I think that part of ongoing feedback loops from the mechanism to the community is really important. And then finally, I think that we'll see, and I know, Jonathan, you're involved in some of these, is this role of independent monitoring, where I think there will be some independent evaluations with obligations or responsibilities to provide public reporting, which will be a very interesting space about what good looks like for a specific standalone report about the effectiveness of a grievance mechanism.
Yeah, we've seen a ton of that in the anti-corruption space, starting to see it in the human rights space. Ouida, any last thought on public reporting?
I see we're right at time, but just to say, I completely second Lloyd's comments there on the need for sort of transparency in reporting, and that it goes beyond that. The only thing that I would add to that is I think there's a real need for more open dialogue amongst companies themselves, really around what's working and what's not. I think there's a real hesitancy to talk publicly about mistakes that have been made. And I think we need to kind of move beyond that so we can actually really implement that piece of non-repetition. and not be replicating, the mistakes that have been made in one location and replicating it in another. So I would say there, in addition to sort of the very sort of public, transparency, I think there needs to be kind of more of the transparency, amongst companies, potentially initially behind closed doors, but then being more public about that as well.
Thanks to both of you, Lloyd Lipsett, Ouida Chichester, two top business and human rights practitioners, two top remedy and remediation practitioners, good friends of the VPs and the VPI. Thank you so much for sharing your thoughts with us. Everybody, I'm sure that Ouida and Lloyd would be happy to answer further questions, as would I, about anything we talked about today. But with that, we'll sign off and everybody stay safe.
Thanks, everyone. Real pleasure being here.
Same. Yeah, thanks, everyone.